Good morning. Thanks for joining us at this Walker Morris webinar on the new failure to prevent fraud offence and what you need to know. I'm Andrew Northridge. I'm one of the partners in the regulatory and compliance team at Walker Morris. I'm joined by my colleague Jocelyn Gergis. Our plan today is that we will talk through the who, what, why, when and how of the offence. We'll talk about, really importantly, the defence and what you need to know to benefit from it if you find yourself in the unfortunate position of needing to. We'll include some practical examples along the way, and we should have some time at the end for some Q&A. We won't be showing you slides during the webinar, but we will send those as a follow-up afterwards, and we will also send some other materials with that. So if we get straight into it, what is the offence? Jocelyn, can you talk us through what the offence is?
Yeah, so the offence is going to be coming into force on the 1st of September as part of the Economic Crime and Corporate Transparency Act. There's a series of offences listed under Schedule 13, and in short, the offence applies whenever an associated person of a large organisation commits one of those specified fraud offences with the intention of benefiting directly or indirectly the large organisation. Okay,
so if we break this down bit by bit, let's start with the offences. There are obviously a list of offences that are specified as being relevant to this. But if you could just pick 2 or 3 out for us and give us some examples of what they would look like.
Sure. So the offences under Schedule 13 are drawn from a number of sources, one of those being the Fraud Act 2006, another being Companies Act, and another being the Theft Act, and finally common law offences. It covers things such as fraud by abusive position, obtaining services dishonestly, and a few sort of more expected examples would be fraud by false representation. So one example of that would be misleading statements from employees, for example, on performance or environmental sustainability to promote products of the organisation. Another example would be fraud by failing to disclose information, which would be an example would be falsifying discharge records to the environmental agency about the permits where the volumes have been exceeded.
Okay, so there's some examples of the offences, and I suppose who are the people that could commit those offences?
Yeah, so associated persons includes people like employees, directors, agents, subsidiary entities. It's essentially anyone performing services for and on behalf of the organisation.
And we've been talking about the organisation. Which organisations does this legislation apply to?
Yeah, so the legislation says that it applies to large organisations, and that would be organisations meeting 2 of the 3 criteria. The 3 criteria being more than 250 employees, a turnover of more than 36 million, or a total balance sheet of 18 million. We've seen that the offence actually seems to extend a bit further than that. For example, it will also apply to organisations and employees that are based overseas where the fraud has a UK nexus. It also applies to subsidiary entities of a parent company if they collectively meet 2 of the 3 criteria. It would also apply to a parent company if the group headed by it met in aggregate 2 or more of the criteria. And finally, it would apply to supply chain entities and franchisees of large organisations. They may not necessarily themselves be a large organisation. They might not meet those criteria, but they can still be captured by the offence.
Thank you. And so we've talked about who it applies to. I think it's also worth noting that there are certain things it doesn't apply to. So the underlying fraud, first of all, has to benefit or be intended. It has to be intended to benefit the organisation, and that can be a direct or an indirect benefit. And it doesn't have to be an exclusive benefit. So it could benefit somebody else as well as the organisation. So it's deliberately drawn quite broadly to cover that. Excuse me. Importantly, it doesn't cover goods. So as Jocelyn was saying, it's where services are provided for or on behalf of the organisation. So it doesn't apply to the supply of goods, and it doesn't apply when a service provider is providing a service to the organisation. It's when it's supplying services for or on behalf of that organisation.
To give some examples of those, supplying goods would be like your utilities suppliers or stationery suppliers. Supplying services to would exclude lawyers, accountants, engineers from scope.
Yeah. And you touched on earlier supply chain partners and franchisees. Can you give us a bit more detail on some of that?
Yeah, so supply chain partners and franchisees, they can fall in scope of the offence as associated persons. Unlike with subsidiaries, so a subsidiary entity is going to automatically be an associated person for the purpose of the offence, whereas supply chain entities and franchisees won't be. There's no trickle-down effect as well, so subsequent parties in a supply chain aren't automatically going to be associated persons. But the issue that we have is that supply chain entities and franchisees that are acting on behalf of a large organisation or providing services on behalf of a large organisation can be in scope as associated persons. So you're going to need to make sure that you have sort of provisions in place, and it's important to note that those provisions only need to be what's proportionate. So for example, subsequent entities in a supply chain, you might not be under a direct contractual relationship with those entities, but you are going to have to consider all the circumstances and whether or not those subsequent entities in the chains will also be providing services for and on behalf of your organisation.
Yeah, and then I think one other important point to note on the offence itself is the territorial scope, the UK nexus that there needs to be.
Yeah, so this is when there's an sort of overseas, or it could be a subsidiary that's based overseas. Again, they can be an associated person of the large organisation that's based in the UK. But in those circumstances, the fraud needs to have a UK nexus. So that is either that one of the fraudulent acts has occurred in the UK or the gain or loss has occurred in the UK. So an example of that would be if an employee in a company in the US commits fraud by falsifying records to entice new clients from the UK, then the UK nexus has been established because of the harm that would have on those UK citizens.
Yeah, okay. Thank you. So that in a fairly whistle-stop way is the offence. It's broader than you might think. It captures more organisations than you might think. But perhaps some relief to know that there is a defence that's built into the Act. It's a similar structure to the Bribery Act, failing to prevent bribery offence. And that is that the organisation concerned had reasonable procedures in place to prevent the fraud from happening. And helpfully, there is Home Office guidance that's been published that gives support to an explanation in terms of what you need to do and what's needed to meet that defence. It's also worth saying at this point that there is industry guidance already being published. There will probably be more published as time goes on, but the Home Office guidance is the key one because that is specifically mentioned in the Act, and it's the one that the court would have most cognizance of if there was a case that went through court. So key concepts in terms of the reasonable procedures, and we'll go through these in detail. There needs to be top-level commitment, risk assessment, proportionate risk-based fraud prevention procedures, due diligence, communication, which will include training and whistleblowing procedures, and monitoring and review. So let's talk about these more in a bit more detail. And I would say, as a starter, top level commitment in many things, but particularly in this is really important. The culture of the organisation, the tone is set from the top, and that's no different in certainly in these offences and the Bribery Act offences. That is the similar structure. It's what a court would be looking for, what a prosecutor would be looking for, is have the top of the organisation set the right tone. So how might they do that, Justin?
Ensuring clear governance in respect of fraud, communicating the company's anti-fraud stance, essentially acting as role models for employees of the organisation.
Yeah, and I think that what we sometimes see is there'll be a commitment statement. This is particularly in the terms of the Bribery Act, which has been around for quite a few years now. You might see a commitment statement, but you don't necessarily see anything beyond that to back that up. So things that you might want to think about in that statement would be naming key individuals, having it signed by perhaps the managing director or the chief executive or the board, and really set out in reasonable detail how important that is to the organisation and some of the consequences of getting it wrong. What it also does is it creates, or it gives you an opportunity to create a clear governance structure within the organisation by defining roles and responsibilities for fraud prevention, letting people know where they can go to if they have any concerns, and making sure that new starters are trained properly on these things, and there is follow-up training and periodic review as we go along. If we look at then the prevention measures and what sort of things might an organisation do?
So these are sort of, again, tied into the defence of reasonable procedures, but you could do things like implementing policies, procedures that tie in with those policies, risk assessments, reviewing contracts and putting in place clauses or attestations. So basically a whole framework of compliance measures, the same way that you would have had for fraud previously, but now capturing the new offence.
Yeah, and I think you mentioned their risk assessment, and I think that's the cornerstone of the procedures. The top level commitment that we talked about is really important, and it genuinely does set the tone for the organisation. But the risk assessment really is where you flush out where the potential problems lie and where additional controls need to be implemented. Because again, organisations will have fraud prevention measures in place. I think part of the risk assessment is to identify where the gaps are and where the risks lie. And it's particularly important with the fact that the scope of the offence and the companies, the organisations that can be captured is probably wider than you might initially think. And so that's why it needs that level of detail and thinking about where the risks lie.
The government guidance gave sort of 3 triangle overarching points to consider when you're looking at a risk assessment or implementing one for this, which would be opportunity, motive, and rationalisation. So when you're putting together a risk assessment, you want to be asking questions like whether or not the associated persons of your organisation have the opportunity to commit fraud, what their motives might be. So, for example, if you're putting any particular time or financial pressures on employees, it might incentivise them to commit fraud. And rationalisation is sort of that last point about culture. Is it difficult to speak up? Is fraud prevalent in the business sector? Is there any repercussions for whistleblowers? So these are sort of all things that you need to factor in when you put a risk assessment together. We've got a template that we've put together that sort of has a comprehensive set of questions that can be tailored to different organisations, and it does sort of cover all these 3 points.
Yeah, thank you. And I think just building on from that, one of the things that a good risk assessment does is it considers the likelihood of something happening and the impact when it does. And interestingly, and it talks about this in the guidance, that even if you've got something that's low likelihood and low impact, it should still be recorded in your risk assessment and documented as to, if you're not taking any action, why you're not taking any action. Something I frequently say to clients when we're talking about Bribery Act procedures is your procedures and your risk assessment will only be properly tested, or would only be properly tested, when there is a an SFO investigator and a police officer at your door asking to talk to you about a fraud and the measures you had in place. That's the only time it gets really tested. And so it's really important to document everything. And even if it's a negative, if you like, that you're not going to do something for a good reason, the fact that you can show that you've thought about it is really helpful.
Yeah. So our risk assessment sort of captures all those elements. So it will, examine the impact and remedial actions of that you put in place for that risk, but it also asks you to consider things like residual risk and any additional planned actions that you might want to implement.
Thank you. And it's also the place, again, we've talked about this before, about the wide range of associated persons that could be captured. And that's, again, the right place to capture exactly who your associated persons are, and think broadly and narrow down is probably the way to go about that. So once you've done your risk assessment, and you've identified the risks, and you've considered the controls that are already in place within the business, and it's also important to think about, and the risk assessment will help you identify what additional controls and measures and procedures you need to put in place to do that. So, for example, earlier on, Jocelyn talked about reducing the opportunity. So things that you might need to do or might need to review are whether you conduct pre-employment and vetting checks as part of your recruitment. And that might not be across the board. You might do that for certain roles within the business, certainly certain levels of seniority within the business, and particularly perhaps higher risk areas for fraud, which I'd say would particularly be in any procurement roles, senior procurement roles, and the finance team, because for what might be obvious reasons, they carry a greater risk in terms of this offence. Consider also, in terms of reducing the opportunity, if you're bringing a new product on board, think about the fraud impact, conducting a fraud impact assessment, and thinking broadly around that. Try and put yourselves in the position of someone who, how could they, if they wanted to commit fraud, how could they do that?
I think you made a really good point about that you might not apply these sort of broad brush to the whole organisation. It might just be applied to specific roles. And I think that's true generally. So the government guidance is quite clear that the offence will apply across the whole organisation. But the offence is also clear that any measures need to be proportionate to the risk that the entity faces. So it might be that the parent company has a bunch of sort of compliance measures that are put in place. They're not all necessary to be rolled out to every subsidiary thereafter. So it is sort of taking that view case by case as we go along to make sure that we have everything in place for reasonable procedures to be implemented.
Yeah, very good point. And things like, we talked about procurement a few moments ago, your procurement processes, and that's throughout the life cycle of procurement. So pre-tender, the contract stage, or project delivery, contract management, all of those. Think about that holistically, and where the opportunities might lie for someone to commit fraud there, and that's where you need to be directing some of your effort in terms of prevention, and particularly after that, invoicing and payments, and who has sign-off authority within the organisation, and at what levels, and is it multiple sign-offs, as in multiple people signing off for a specific amount, things like that. We also touched on earlier, very briefly, the sector guidance. UK Finance has already published guidance. It's helpful, and I think there'll be more sector-specific guidance that will come out. But it's just important that it is only guidance, and it doesn't absolve you of the responsibility for taking the steps that you need to take as part of the organisation. So we've covered the opportunity. What about the motive?
So this is where we were sort of talking about if you might have particular financial or time pressures. it's the sort of thing that could encourage employees, for example, to commit fraud. So, for example, if you've got particular targets that need to be met, you might need to consider whether those targets are reasonable or whether those targets are going to push people to do things that they shouldn't be doing in an attempt to achieve them. So it's just about making sure that you're not essentially putting motives out there for people to take and go and commit fraud with. You don't want to be giving any additional reasons.
Absolutely. And I think another aspect of that would be your bonus structure, your bonus framework. It's really important, particularly people in the financial services sector will have seen this for a long time, that the bonus framework has to be aligned to the right behaviours. But it's certainly now something that's additional to be thought, that needs to be thought about in terms of what behaviours are rewarded in the bonus structure.
And if you want to consider sort of the third party associated person perspective, so supply chains, for example, you'd want to consider sort of what your expectations are of them, whether they've got any particular concerns or whether you're putting any pressures on them commercially such that they might fear, for example, losing the relationship if they're not meeting certain targets. So it kind of sort of filters out to all associated persons in the same way.
Yeah, absolutely. And then the other thing you always hear in criminal law, means, motive and opportunity. So if you can also reduce the means of someone committing fraud, that's another barrier that you can have in place. So again, it's some of the things we've talked about before. It's the training of individuals, and again, that might not be the same training throughout the organisation. The higher risk roles often have more, or would expect to have more detailed training than some others. But it's also your existing diligence procedures and your sign-off procedures as well. So that covers means, motive and opportunity. What about fraud detection processes and red flags?
Yeah, so recognising red flags was sort of the first step to being able to prevent fraud, because, you know, if you spot the red flags, you can identify what the issue is and start putting the relevant measures in place. So red flags that you might want to sort of be looking out for would be things such as inflated revenue, unusual accounting practices, abnormal expense reporting, unjustified discounts. I think that's probably quite a big one. You know, if discounts sort of are going through without the proper approvals or documentation, that would be an obvious red flag to be concerned about. And then your sort of classic, you know, falsified documents, non-standard payment terms, and so on.
Yeah, okay. Those are the things to look out for. Warning signs, red flags to look out for, and places where you may find you need to put controls in place or potentially strengthen your existing controls. And on that, the Home Office guidance talks about due diligence, and I think it's important. Every organisation of any size at all now will have due diligence procedures throughout the organisation for lots of different things. I think what's important to note is, don't assume that because you have diligence procedures on something that they are the right ones for this. They may be very helpful and often a great starting point, and in some cases they may be sufficient. But the key point really is to review them in the light of this new offence and what might happen.
I think we have these sort of bribery and tax evasion, failure to prevent offences, which came prior. And, you know, I think it's important to note that under this failure to prevent fraud offence, there's a wider range of offences. So those sort of due diligence checks, whatever, you are going to have to be a little bit more comprehensive when you're going through them, because I think it's easy to fall into the trap of thinking, oh, well, we've got fraud policies, or, you know, we've got anti-fraud clauses in our agreements. But the problem is now that this offence is going just that little bit further, so they are going to have to be reviewed again, and you are going to have to diligence sort of properly to make sure that you've got what you need.
Yeah, absolutely. And then one of the other the two more headings that we need to talk about from the guidance and the support that you can get in terms of procedures and making sure that they're in the place they need to be. The next one is communication. So we've talked about training, but
yeah, so you just want to make sure that you're communicating across the organisation so that all employees are aware of what their responsibilities would be. So there's the obvious sort of training where, you know, you make people aware of reporting lines, etc. But the communication, it could just be, you know, sort of putting up posters or sending out emails, and just making sure that people are aware of the latest in terms of your fraud risks and what they need to be aware of and what they need to be doing. Normally, if you're doing training, say annually or biannually, it might not be capturing things real time as they're arising. So you just want to make sure you're staying on top of that.
Yeah, absolutely. And I think other things, while we're on the subject of training, one question we've already been asked is whether companies should deliver training to their associated persons. Obviously, their employees who are associated with, but third-party associated persons.
Yeah. So what we'd say there is that it shouldn't. You know, they may have their own comprehensive training plans in place. They might have their own comprehensive compliance framework in place. You can't rely on that in your defence. Essentially, you're going to want to make sure you have your own full framework in place. You can, if you like, put into clauses that they have to be sort of doing X, Y, Z. You can say, you know, you need to be on top of your training communication in relation to this offence. But ultimately, the measures that they have in place aren't going to protect you if it's found that one of your associated persons has committed fraud for your benefit.
Yeah, and then I think in the wider communication piece, you know, also think about your whistleblowing and speak up procedures. Again, most organisations these days will have some form of whistleblowing and you know, positively encourage speaking up, particularly where employees have an ethical concern or a moral concern about what's happening. So again, that would be something that is a good procedure to have, but it would also it would demonstrate both to the employees but to the prosecutor and the court, if you ever needed to, that you've developed that culture and that commitment to ethical behaviour. And then finally, the last heading in the guidance is the monitoring and review. So what should people be doing there?
Just regularly revisiting that framework that you've put in place, making sure that any fraud attempts are being investigated, making sure that fraud is being detected. So you've put all this compliance framework in place. If it's then transpiring that X, Y, Z is happening without your knowledge, you're going to need to change your framework. You're sort of going to need to go back and make sure that you're plugging those gaps as they arise. Yeah. So it's just about making sure that you sort of stay on top of it. Yeah, I would say probably an annual review along with the risk assessment.
Yeah, absolutely. And annual review along with the risk assessment, as Jocelyn said, and any significant change in business line or new product, new service or whatever, maybe it's certainly something at that point that you should consider reviewing, even if the decision is ultimately made that it's not needed. There are other things that you can do in terms of monitoring and review, as well as the reviews we've just spoken about. There will be, as time passes on, there'll be cases will happen, there will be deferred prosecution agreements, and you can read those, learn from them, because they do give a good steer as to how the Serious Fraud Office in particular, which will probably bring most of these cases, how they're thinking. And you may also want, depending on the level of activity that you need to have, you may need to consider external support, which brings us on nicely to the support that we have found ourselves providing.
Yeah, so I think we've mentioned already, you know, we've got this risk assessment template. We've sort of rolled that out to a couple of clients who are taking that away and starting to, you know, look at that internally. We've not had those come back to us yet, but sort of other things that we've been helping with in the meantime are third-party contract reviews. I think that's formed sort of the bulk of what we've been doing. The issue that we have with this offence is that it places emphasis on outward fraud. So typically the contracts that people have in place or organisations have in place already are designed to cover inward fraud. That is fraud where the company is the victim. Obviously now this offence being about the failure to prevent fraud is sort of flipping that script, and we're now looking at outward fraud where the company is the beneficiary rather than the victim. So we're having to review contracts, and I think the biggest issue we're encountering is that clients are sort of wanting hardline parameters. Is this contract in scope or is it out of scope? Is this an associated person? Is it not? And the difficulty is that sort of this offence hasn't prescribed those defined parameters, and actually has done quite the opposite. It's left discretion to organisations to determine what those parameters are in view of all the relevant circumstances of their contractual relationships.
Yeah. So again, it does come down to it's what approach you take in terms of that contract review. You may find that you have buckets of contracts where you've got similar suppliers, or they may be associated persons, or you may need to do the analysis to whether they are or not. But once you do that, you do need to think about them at a contractual level, or at least dip test the bucket, so to speak, so that you're not taking too broad brush an approach with it, I think.
And we've had sort of issues with certain contracts where, for example, you've got an agent who's acting on behalf of multiple entities. The question then is, when are they an associated person of us, our entity, our organisation? And the answer to that is essentially when they're acting as an associated person for your organisation. So if there's a contract where an agent acts on behalf of multiple entities, they won't be an associated person for the purposes of this offence for your organisation when they're acting on behalf of another principal. So I think that's sort of another one that we've had come up quite a bit. And in general, despite the fact that we haven't got those parameters, the sort of guidance that we've given in identifying which contracts are likely to fall in scope is looking at things like contractual complexity, so how many parties there are to a contract, also considering elements such as sort of financial exposure under the contract, and lastly would be sort of clear obligations, sort of accountability, oversight of that contract as well.
Brilliant, thank you. So we've covered a lot of ground so far. I suppose my next question is there anything I've forgotten to ask you?
If there's a difference in treatment between high-risk contracts and low-risk contracts.
Is there a difference in treatment between high-risk contracts and low-risk contracts?
So for high-risk contracts, we've generally been recommending clauses. So high-risk contracts would be things like sort of agency and consultancy agreements, supply chain distribution contracts, or financial services investment contracts. And in those, we're sort of suggesting, substantive clauses that are sort of imposing obligations on those associated persons to make sure that they're complying with the requirements of the fraud prevention. For low risk contracts, so these would be things like employment contracts. In an employment contract, any fraud that can happen is sort of isolated to that one individual. And the other sort of low risk contracts you'd be looking at would be routine service contracts. So utility suppliers, for example, they're low value contracts with quite transparent deliverables. So unlike for high risk contracts where we're suggesting, sort of full clauses, we've said for low risk contracts, generally then attestation would be suitable. So just, to say that, I respect the offence, I understand the offence, I won't be committing fraud, rather than having sort of set out obligations for employees on an individual basis.
And that brings me nicely on to my final question, which is that what do people need to be thinking about if an associated person also has to have fraud prevention procedures for its own purposes, because perhaps it's a large organisation and it's within scope of the offence?
Yeah, so it's always helpful if your associated person has a strong compliance framework. It obviously sort of takes some of the pressure off. You don't have to be quite as worried about them. They're on top of it, but it doesn't absolve you from having your own. So there's no easy way to say that. You are still going to have your own. You are still going to need to have your own controls in place, and you're going to need to make sure that those are considering circumstances where the associated person might commit a fraud that would benefit your organisation, because they're very unlikely to have factored that into their own compliance framework. They'll have been looking at it from the angle of their associated persons benefiting them. So of course you're going to need to have your own framework in to make sure that you've captured that discrepancy, caught that gap there that they won't have considered.
Yeah, absolutely. But it is always helpful to, if to the extent they're willing to share them with you, that it helps your compliance to show that you've done that diligence of your associated person.
Yeah, and I think it's important as well that sort of once those clauses are in place and once you've got those policies in place, that you make sure that you're actually monitoring whether or not they're being complied with. You might have to sort of bolster your procedures to make sure that they're not just words on a piece of paper. You've got to make sure that you're sort of actually implementing them at each stage.
Yeah, thank you. I think we're about finished.
Yeah.
Thank you again for joining us. If there have been questions coming through on the chat, we will follow up with you with those. There'll be a recording that we will circulate shortly after this event. I think that's all. Thanks again. Goodbye.